I'm not going into every one of the issues. Your lordships have heard many learned submissions on the
We're supposed to wind up today,
Yes,
but we are granting one extra day, please. So bear with us, and we need
Please, my
to
lords.
very quickly close it.
my lords, my aim is to do this. Your lordship has various issues. I want to bring it down basically to what is Article 25, what is Article 26, what are the parameters in these. Much has been spoken about religion. My lords, there is a lot to be said about religion as religion. But I'm more concerned about what Articles 25 and 26 say. And in particular, I want to answer certain questions which have been raised by your lordships during the hearing, which is why I'm not going to my huge written submissions. I'm going to a very small 6 propositions.
Better address your principles which you want
Absolutely. So, my lords,
to. Not our questions. We keep on asking questions.
my lords, what I'm going to address, my lords, are on these broad principles. It's all in one.
Yes.
6 broad principles.
Mention it, please. He's giving another note, small note.
In which volume your arguments are there?
My lords, my arguments are in volume 1.1,
Better we take this piece.
page 500, 507. My lord, at the time of filing, the petitioner, my lords, was the president of the VHP Kerala, and my lords is currently the general secretary of the Sabarimala Karma Samiti, as also the natural chairman of the Sabarimala Ayyappa Seva Samajam. My lord, can I just give your lordships the broad principles on which I want to go?
Yes.
Before which, I would like to answer your ladyship's one question earlier on what is conscience. My understanding of conscience, pure and simple, is it's a moral compass within which each one lives. If we understand that to be conscience, we look at it as our own moral conscience of what I feel is right and wrong, which someone else may not give him equal importance to. But there are what we have always called absolute rights, absolute wrongs, which are pernicious behavior, which you cannot claim protection of conscience. In that background, can I just take your lordships through these broad principles? First of all, religion, for all the learned discussion on religion, boils down only to this. It is an expression of belief in a superior force. A particular God is a personification of that belief. Why I would like to emphasize this is that, especially I know in the South, probably all over India, a temple is really an abode of a particular deity. It is where a deity in the form we want to worship that deity is. So, for example, if we take Ayyappa, Ayyappa has in various forms. Each temple worships that deity in that form, treating it as the home of the deity. For example, Guruvayur, while it is Krishna the child. The entire religious feeling is towards the deity in that form, and to that extent, please consider my primary submission, my lord. A temple, a religious institution, is really an abode of a deity.
Yes.
Which is where this question of essentiality test, I am not able to understand. Why? If it's a religious practice, it is a religious practice, and with freedom of conscience, which does not trample on somebody else's toes, I can follow my religious practice. The moment we say essential religious practice, it becomes a question of fact. That question of fact then is left to the courts to decide an ecclesiastical matter, which we say we will not do. It becomes a jury question. Is it essential? Is it not essential? And at the same time, we say the courts will not enter into ecclesiastical matters. So this concept of essentiality is not relevant. What is relevant is the concept of whether it is a form of religious worship. That is all. And whether that form is found either in the Shastras or through long custom or through long usage or is the manner in which a group of people want to worship the deity. And my lords, we cannot go beyond that. My lord, where I disagree with some of my colleagues is that Article 26, I believe, certainly does not exclude Article 25. The two have to be read in tandem. The word class in Article 15, here again I disagree with some of my colleagues, does not exclude only those contemplated under Article 17, but will apply to castes as in communities, as in class as in caste, communities, others. But it is my submission it will not apply to gender. Because where gender is intended elsewhere in Part 3, gender has been referred to and has not, my lords, been passed in a generic class. The power of the state under Article 25 includes denomination. So according to me, 25, 26 have to be read together. The state certainly has the power under 25, 1A and 1B, qua denominations also. And there, to the extent that it was said that 26 is not subject to 25, I do not agree with that submission. I, on the contrary, say, yes, it will apply. However, my lords, the power of state under Article 25 would include denominations, but only qua class and sections. And it is my submission, although the disjunctive is used as or in Article 25, but only for reasons of social reform and welfare. My Lord the Chief Justice earlier said, which is the idea I subscribe to, that whether considering a particular practice and whether removing that practice is for social reform or not will be a matter to be decided in a particular case. What is absolutely barred by the Constitution, of course, for example, Article 17. But the others, what nature of social reform? And the social reform has to be taken qua the activity, qua the form of worship, qua the deity, and qua the manner of worship of that deity. You cannot take social reform in an abstract sense. You have to say, for the worship of this particular deity, in this particular form, this particular custom abhors the conscience. This particular custom should be done away with. Your ladyship referred to sati. That's a very typical example. Very typical example. Should be done away with. But that will be tested on a case-by-case basis, and there are no absolutes so far as that is concerned. And there can never be absolutes. And so, while it is recognized that for a larger good, for social reform, and here my Lord Justice Bagchi pointed out that social reform could be read in lines with directive principles of state. When I look and fundamental duties. When I look at the rights under Article 25, social reform or not, in keeping with the directive principles, you will find when you go through it, my lords, I'm not going to take your time. We do not deal at all in the directive principles with gender equality in the access to any place of worship, irrespective of the nature of worship. It is not even an aim to achieve gender equality. While the aim is to achieve gender equality in employment, in other manners, access to places of worship or freedom of religion does not include this concept of gender equality even in the directive principles. My lords, therefore, Article 25(2)(a) deals with secular activities in a religious practice, for example, property. 2B deals with the state's power qua particular institutions in the interest of social welfare and reform, although the words used, if you would kindly see, says providing for social welfare and reform or the throwing open of Hindu religious institutions, should correctly be read as providing for social welfare and reforms inter alia by throwing open the Hindu religious. It can't be, I can just throw it for no reason. But like your lordship said, that's a matter to be tested in a given case.
Very difficult to accept this.
Sorry, Malad.
Very difficult to accept this. Because if you accept it, it will exclude others also.
No, I put it in this manner. I am saying, please take the color of throwing open the Hindu religious institutions to the words preceding it. That is, actually, that should be the nature of my submission.
In terms of the defining or what constitutes social reform.
Yes. For that purpose, yes, you can throw open an institution, but you throw that institution open for the purpose of social welfares and reforms. That is the manner in which I'd like to interpret 25(2)(b). So it is not an absolute right. It is a right which is certainly circumscribed by the fact that the state can act in a larger good, but when considering the larger good, cannot open out the temple to and say X can go in or Y can go in without going into the question as to whether it is for furtherance of social reform or welfare. That is the submission I want to make to my lords. It has to be read together. It cannot be separated. The two have to be read together. My lords, so far as denomination is concerned, much has been said, many judgments written about denomination. My lords, I'm because of the time, I'm not taking my lords to the various interpretations. I've tried to concise my arguments as much as possible. Not so that. Denomination, basically, like I said, for religion also, I gave your lordships what you might feel is too simplistic a meaning. But that is the way we all understand it. Religion is a belief in a superior force. God is the particular God, the deity, the idol, is my personification of that belief. I bring it down to simple terms. Now, denomination,
Mr. Sundaram,
please.
is there not a fundamental contradiction in the argument if you say that we should read providing for social welfare and reform, inter alia throwing open? The fundamental contradiction would be that providing for social welfare and reform can only be for a limited section also, but here throwing open is for all classes and sections. So that is a different.
Yes. My lords,
social reform and welfare can be limited only to a particular group within a denomination.
social reform so when you open a religious institution to all classes and sections,
But social reform
You're
and
doing
welfare
so-
can be limited to a particular subsection also. But
Yes.
this is to all classes and sections.
Yes.
This is blanket. That is why throwing
All or
is
some.
blanket.
All include
How can it
some.
be inter alia? How can it be qualified by?
my lords, I read the word all in Article 25(2)(b) to be all including any part of. All is not the whole class. Eliminating, it is a question of all classes and sections. That is, you have the right to open it to any class and section, which is necessary for social reform. But there again, please, my lords, keep in mind that my submission is classes, sections does not include gender. That is but looking at the words themselves, when I say to all classes and sections, obviously a particular notification of the government, a particular action of the government, a particular law of the government would be pertaining a certain class. It need not be the world at large. It need not be the world at large, but class would mean all those similarly placed will necessarily, otherwise it runs foul of Article 14. So when we say to all classes and sections, all similar classes, but not universal all, that it's all or none.
Providing for social welfare and reform, that is not qualified, but throwing open is only restricted to sections of classes of Hindus.
Yes, absolutely.
Reform can be to any religion.
Yes,
On
my
that
lord,
ground it can be made. But this restriction of throwing open is only, that is why it is qualified for sections of Hindus.
absolutely, which is why if your lordship also sees,
Disjunctive. It cannot be read in the same thread.
in which case, my lords, I may explain why. For example, if we take, my lords, Muslim places of worship, my lords, definitely it is not thrown open, and the state throwing it open for access outside the religion may not come up at all. But most institutions, temples, Hindu institutions, like take our Sabarimala itself. It is, my lord, religiously Catholic. Any religion, person of any religion can come in. It's not only a Hindu. Provided you do
No, even in dargahs and all, everybody can go.
Dargah, yes.
So there's absolutely no restriction of anybody.
Dargah, yes. But I'm not sure, my lord, on whether the rule is for all mosques. Dargah, yes.
Different sections
Yes.
have that.
It's only in respect of a mazar, not when it is a mosque, there's no bar for a woman to enter. It's a mazar.
Not women, my lord. I'm talking about people who do not profess that religion at all. I'm talking about
There
their.
is no bar for
No, my lord was putting the question to me.
non-Muslim to enter a mosque. The question is whether they can worship inside.
Inside. That is the point. That is the point. Because if your lordship sees, you're asking me the question on B,
Well,
whether the first part of B,
reverse thing will apply in respect of a temple. A non-religious, a non-Hindu can definitely enter a temple, but the religious practices may not permit offering of namaz inside the temple.
but your lordship is talking about a mosque, but I'm talking about,
Just put the reverse.
yes,
The same injunctions may apply in all religions.
in some temples, not so. For example, Sabarimala itself,
Does Sabarimala permit offering of namaz inside the temple?
not namaz, my lords, the
So-
form of worship, which is what I'm coming to.
So the form.
You cannot sit, for example, I can't go to Tirupati when the Suprabhatam is being played and say, I want to sing to the praise of Lord Shiva at that moment. When I go to a temple, I accept the form of worship of that temple.
Your point.
What we are asked today in this case is to see whether I can insist on access,
Sir, your point.
changing that form of worship. That is the whole moot
Your
question.
point is well taken, but the 25B does not speak of worship, it speaks of entry.
I'm coming there. My lords, the entry itself can be thrown open today, but the question before your lordship is, if a particular institution says the nature of the deity is such that it belies the entry of a certain person, would the state then come in and say, I'm sorry, you cannot belie the entry of such a person unless the refusal is pernicious. Refusal traces to Article 17. The refusal traces to something which is shocking to the human conscience. And that's why, as my Lord the Chief Justice said, that's a matter which will have to be seen from case to case, but cannot be said as an absolute.
Mr. Sundaram, the thrown open part is very clearly, it is reiteration of 17.
Absolutely.
It's replantation of 17.
Absolutely.
Replantation of 17, that part probably is not.
That is why I was answering my Lord by saying classes there are similar sections which are of a similar class. You cannot distinguish.
And sections of the Hindu.
Absolutely. Absolutely.
Therefore, that no, there should not be any mistake that 17, a constitutional declaration and a very powerful right of 17, that has been reiterated with reference to the.
My Lord pleases. In fact, that is, I couldn't put it in any other way, my Lord. That is my submission. My Lords, I'm now coming to what is a denomination. My Lord, denomination is nothing more, because we have realized one thing. If a temple is an abode of God, God is my personification of my belief, and that particular God is in a certain form. My denomination is in what manner I wish to offer worship, and to God in what form. It's not that you have to go further into denomination. If I see God in a certain form and in none other, and I see his worship in a certain manner and none other, I form a distinct class from people who see God in another form, or who want to offer worship to him in another form.
Need not be in one form only. It can be in many forms.
That is my choice. Exactly. Your ladyship is right. That is my choice. But let us say there's a collective group of us who see him in a particular form and who see a means of offering worship to him in that form in a common way. We are a denomination. We need not go further by tests of denomination. Is there an institution? Is there a purpose, etc.? We are a group. We are a denomination. And to answer my Lord Justice Bagchi's question, what if within the denomination can you not debate? Of course you can debate. On the contrary, you can go one step further. You can say, I'm sorry, a group of this denomination doesn't agree with this form of worship. We have a totally different form of worship. You can form another denomination. That itself will become a denomination. Manoj, so let us not go into this concept of denomination like a great matter to be legally discussed as to what would legally connote
What you are
it.
saying, denomination is something which is to be left to the collective believers.
Absolutely.
Don't go into this, that's all. Whatever may they do, it is their common belief. Small variation or same thing, whatever we can say, so long as they decide to have a group and then they have decided to have faith and practice and profess, and
Absolutely.
get lead at that.
That's why I said, my lord, my attempt is to very simplify the two articles. I know there's a lot of literature on it, but I want to simplify it because we are dealing with 25, 26.
Are collectively managing their affairs.
Absolutely. My lord, therefore, please see the definition I have given, my lord.
Need to have a formal organization as such.
You don't need it.
See, that is the reason, as you rightly said, you can't dissect 25 from 26. It's a progression from that. You have to, it's a next step.
Absolutely.
You become, see, the denomination will become part of 25. Additionally, how to manage and administer.
So a denomination itself is also protected under 25,
Naturally.
Yes.
not only under
Whichever way you
26.
look at it, either through your very common believers or by your own self, whichever you like it, that's why rights and liability are determined in 25.
Absolutely.
So far as the belief, practice and profess is concerned.
In fact,
In
that
terms of management, other things, so administration, that comes.
would be different. My lord, there also owning property could be a secular activity. That is something
That's
else.
correct.
But my lord, this is why I disagreed with my learned friends who said that 26 excludes 25. Because why? I see 25 as an added ammunition for an institution, for a group of people. It's a right to practice a religion. So if I want to practice a religion, I can practice religion in my form of worship, provided it's not pernicious. Malad, that's why please see my definition, what I've given to the denomination.
See, propagation of religion can also be a matter of religion. See,
It is. As your ladyship knows, I can be an atheist and that can still be a freedom of conscience.
propagation of a religion is also coming under 26B.
Yeah, absolutely. You're absolutely right. Absolutely right. Yes,
It is a matter of religion.
it's a matter of religion. So therefore, the two are intertwined. I said 26 cannot be divorced from 25. The two go together.
Your point number E has been broadly argued by everyone in the same manner.
Understood, yes.
There is
No,
probably there is no
I
variation.
saw there was a slight digress because there was some arguments taken before your lordships that 26
Does not say subject to.
is and is not covered by.
We understood the argument. No problem.
That I want to dispel that from my submission.
no.
That's all my aim.
Your point E is only with respect to the meaning of denomination.
Yes.
Broadly,
Manager administrator.
Well,
broadly argued in the same manner.
point E, I want to say it's nothing more than a collective group who offer worship to God in a matter distinct from others, who have a common religious belief but express their worship in a different way. That is, we all might have a religious belief, common religious belief. We are all Hindus, but we express it in a different way. Well, let's say if we accept that is a denomination.
Come to.
I'll come to it. If we accept that that is a denomination and we accept that 26C B gives the powers to manage my affairs in a manner of religion, then my form of worship of the deity who reflects my understanding, which is the Nastika Brahmacharya, the question then is not an absolute. Article 14, how are you distinguishing against women? That is not the question. The question says your denomination's manner of worship of a deity in a particular form. Is this exclusion rational? That is the only test.
I will detail this, will tell you why. 26 is on a different issue. with respect to administration and management. This public morality, health, it can be only with respect to management and administration.
Absolutely.
Otherwise, you go under 25.
25.
You will not have any better right than the believer.
Which is why my lords will say,
Believer, a common believer, you are only a manifestation of those persons. That's all.
which is why my F, proposition F,
That's why
according to me, part 3 will
But
apply to
saying-
26 also. Part 3 applies to 26. In fact, F, I have said,
difficulty, but restriction only with the public order, morality, and health. That's where the problem comes. If you come under to 26(2)(b), 25(2)(b), then there is a matter. You can't say it will come under partially. It will come under public order, morality, and health. Then other part will not come. It will come.
I said both are intertwined. That is my submission.
That's correct. That's
They
what
are
you take it.
intertwined.
Take it up.
My lord, let me explain why.
Is conspicuous by its absence. Otherwise, they could have said subject to part 3. Or they could have said subject to Article 25(2).
My lord, there,
Said in Article 26.
there my answer to your ladyship is this. If 25 gives me the right of freedom of religion, it is a fundamental right of mine, like every other fundamental right. It is tempered by its own restrictions. Like every other fundamental right, it is tempered by its own restrictions. If I am given the fundamental right of religion, it is my right, which is an individual right, or my right as a collection of individuals, it's our right. So we trace our right to 25. 26 says the state indicates, state will not interfere in the manner of your exercising that right. Subject again to 25(2). So I'm saying you can't divorce 25 and 26. My right, your ladyship will see
That's
26
what Z was also saying. Your rights are subject to 25(2).
and 26. My right under 26,
Then we got it. We understand. We appreciate that.
my right under 26 is a manifestation of my right under 25.
Okay, we appreciate that. We follow it.
And if 26 does not provide for any restriction other than public order, morality, and health. However, we cannot say that so far as 26 is concerned, 25(2)(a) and B cannot be applied. It can be. So, my lords, how, I ask myself, could anyone try to divorce 25 and 26? You cannot do so. Foundation, the fountainhead of your power is 25 of my right.
It cannot be in piecemeal. Either you take it or leave it. That's all.
This is one area where some of you are at variance. We will examine.
Please, my lord. But I'm giving the reason why I am canvassing it from the angle I am. The reason I'm canvassing it from that
You
angle,
can say is your approach appears to be more balanced than the others.
I would think so, my lord. Whether your lordship thinks so is a different matter.
Subject to hearing them.
No, the only point I want to make is this. My lords, I also had an argument saying that 25 was individual, whereas 26, no. The right to profess my
We
religion.
understood it fully. No problem. We understood it fully. That's what.
My lord, these are the broad propositions on which I would like to. I have, my lords, placed an aid memoir elaborating these. I'm not going to take my lord through it, but I cut short everything in a different way from my original submission based on much of what I'd heard and much of what I felt I would like to address my lords on. But in short, my lords, what I would like to say is this. In short, what I would like to say to your lordships is this. Number one, classes does not include gender. Number one. My lords, I've given various reasons in my aid memoir, but I'm just summarizing.
Yes, yes.
Class under 25(2)(a) deals only with secular activity. The 25(2)(a) deals only with secular activities, not with theological, not with religious. Article 25(2)(b), when referring to classes, does not refer to gender.
That's it.
And therefore, the power to throw open for a gender is not traceable to 2b. If at all it is claimed, it can only be claimed on the right of 14 because part 3. But if you take 14, you must see whether there's a rational, intelligible differentia, rational reason for it. Now, if you take that reason as being the reason being it is felt by this people who are worshipping this particular deity in this particular avatar, in this particular form, that being a Nastika Brahmacharya, this form of worship is called for. And if that is not found totally arbitrary, illogical, perverse, or reprehensible, your lordships would not interfere on a matter of somebody claiming a right because of Article 14. 14 has no role. My lords, and finally, the submission which I have to make is that 26B is nothing but an elaboration of a right I am already granted under 25(1).
That's pretty good.
My lord, this in short are my submissions.
This is the first point you were saying. That's the first thing.
My lords, I have given an aid memoir. I just want to refer there, my lords, to page 5. My lords, page 4, Roman 3, Roman 4. The pages are at the foot of the page. What is the meaning of the expression sections of Hindu occurring in Article 25(2)(b) of the Constitution? Article 25(2)(b) itself, referring to classes and sections of Hindus, has to be kept in reading in mind with Article 17, cannot be taken as encompassing gender, especially since Article 25(2)(b) refers to Hindus, includes offshoots of the same, and not to other religions. Because your lordships will see the explanation included Jains, Buddhists, Sikhs, Buddhists, which are offshoots of the Hinduism itself, and not to other religions, which makes it clear that classes referred to therein as is contemplated in Article 17 and in juxtaposition to Articles 15(2), 16(2), where there is an intention to include gender, it is specifically mentioned. Sections of Hindu is only used in the context of Article 25(2)(b), being Hindu religious institutions. Concept of gender would be part of 25 as a whole and not to 25(2)(b). The intention of the makers of the Constitution cannot be presumed to ensure gender equality in the context of Hindu religious institutions to the exclusion of all other religions and their institutions. Your lordships will find I'm supporting this with this. Wherever gender equality is called for, there are specific articles dealing with it. My Lord Justice Bagchi said directive principles. Please see, in directive principles, Article 38, 39, deal with gender equality, but where? In providing employment in those areas. So
that is applicable for everybody.
So gender
across the board.
Across the board. So gender equality is not taken particular to a manner of worship. So gender equality is not an integral part of a manner of worship.
Not true for Hindu religion. If it is there, it should be there for other religions also.
Absolutely. So my whole point is gender equality, while as a notion, is something which is to be furthered. Where it is required to be furthered is specifically provided for. Otherwise, it is not an integral part of that religion. If it's not a part of that religion and it is a rational manner of distinction, the courts would not impose Article 14, which is exactly what has been done earlier. By now, the whole genesis of the earlier case, if you look through it as a thread, it's Article 14 is the thread of the entire judgment. Whereas it is my submission, Article 14 has no relevance here. That is my submission. Now, please see, I've dealt in Roman 4, and I conclude with this, my lords. I realize that I did say I'd finish soon. Roman 4, interplay of Articles 25 and 26.
So you argued, somebody we got you have noted your point now. See, this is again, you started with this only.
Yes.
That's agree. You can note it down, that's all. No issue.
Absolutely.
Yes.
So, my lords, I will conclude it with this.
Yes.
That neither Article 21 or 14 would have any dealing with it. When your lordships have the time, please see my note on it, but I didn't want to take more time. You've heard enough. But I wanted to highlight these were the aspects on it.